Shipul, I think we can start. The professor in charge has also joined us.
Yes, ma'am. We'll begin now. Thank you so much, everyone, for being present here. My name is Shipul. I'm a third year student here at Law Center 2, Faculty of Law, Delhi University.
Hi everyone, my name is Kanak, a third year student from Law Center 2.
We welcome our esteemed panel today, Dr. Anita Tagore ma'am, Mr. Shonee Kapoor sir, and our professor in charge, Dr. Mahavir sir, our teacher convener, Dr. Vageshwari ma'am, fellow teachers, and all the others who've participated today on the discussion of marital rape, decoding the consent within marriage. Before we move on to a formal discussion, I would request our teacher, professor in charge, sir, to kindly say a few words. Thank you.
Thank you. Am I audible?
Yes,
Yes,
sir.
sir, you are.
Okay. Respected, esteemed and worthy colleagues and beloved and dear students, very good evening to all. Today, we are having very burning and emerging topic, that is marital rape, decoding the concept of consent within the institution of marriage. As all of you know, that today marital rape is a burning issue in contemporary times. Writ Foundations versus Union of India and a series of petitions demanding the need to criminalize marital rape are currently being heard by a bench of the Delhi High Court. The issue was earlier raised in 2000 in Sakshi versus Union of India, but the Supreme Court had declined to criminalize marital rape by saying that the courts cannot legislate in the garb of judicial interpretation. Exception 2 to Section 375 of IPC was drafted in 1860, an era of Victorian patriarchy, where women were not seen as equals of men. It is argued that there is a need to acknowledge the defects in the law, keeping within the principles of the Constitution, which we enforced in 1950, and the status of equality and dignity that it accords to all citizens. Provisions in IPC and CRPC classify victims of a rape based on their marital status, that is married but separated, or unmarried. Suggestions by the Justice Verma Committee report to strike down the impugned section did not find favor with the states, and marital rape used to be exempted from criminal prosecution. In November 2014, DMK Member of Parliament Kani Moji proposed a private member bill suggesting amendments to criminal law by removing the marital rape exemption, but it was not considered. In January 2019, the Congress MP Dr. Sasi Tharoor also introduced a private member bill relating to sexual and reproduction health of women seeking removal of exemption clause. However, the bills lapsed due to failure of support. The majority of nations in the world criminalize all forms of rape, but India, along with 35 other nations such as Pakistan, Afghanistan, Iran, Saudi Arabia, Yemen, Bangladesh, etc., continues to provide this exemption. The reason is that India has many gender-specific laws that favors women, and there is a threat of such laws being misused by disgruntled wives, their husbands. Another factor is that such a provision could adversely affect the institution of marriage. This is a complex issue, and we need to have a well-informed discussion on this. Today, we have invited two very eminent personalities to speak on this topic. I welcome Dr. Anita Tagore, who is an associate professor at Kalindi College and is well known as a feminist writer. I also welcome Shonee Kapoor, who is a very well known and successful men's rights activist. Incidentally, they both are alumni of our Faculty of Law, University of Delhi. I proudly welcome them and look forward to a engaging discussion. Today, I'm also proud to announce that we have successfully come out with 2020 edition of Delhi Journal of Contemporary Law. Despite of the pandemic, our editorial teams have worked tirelessly to bring out this volume. So I congratulate them and congratulate to the entire family of Law Center too. Thanking all of you to join us. Thank you. Thank you.
Thank you so much, sir, for briefing us about a little history of this provision that we are here to discuss today, and also about why we need to talk about this burning topic, which is impacting more than 50% of the population here.
Certainly, Shipul. We would also like to extend our warm welcome to Dr. Anita ma'am, who is an author, and she's also an associate professor at Kalindi College, University of Delhi, and she teaches political science and is also a socio-legal researcher. We welcome you, ma'am. As well as we would also like to extend a welcome to Mr. Shonee Kapoor. He is a legal consultant with almost 8 years of exposure from various courts of India as a litigant and also as a legal professional. Apart from that, he has also counseled people suffering from the misuse from matrimonial laws in India. And he has also handled pre-litigation briefs for effective diffusion of problems. He also has a very rich experience in drafting petitions, replies, contract, and mediation. We welcome you, sir. Further, we would like to invite Anita Tagore ma'am to address the gathering.
Thank you so much. I'm audible, right, to everybody?
Yes,
ma'am.
Okay. Thank you so much, Faculty of Law, Center 2. Thank you, Vageshwari. Thank you, Professor in charge, for a very kind introduction. Today, being here as to my alma mater, it gives me, I feel really proud to be talking on a subject which is really close to my heart. So since we have so many participants, I will first speak for a couple of minutes and then maybe take questions. Is that the framework in which we do the talk? Yes?
Ma'am, we are generally taking questions at the end of the discussion, but if you would are comfortable first, we can take
No,
that.
it's okay with me. Okay with me. So around say 20 minutes, would that be all right?
Yes, ma'am.
Okay, so you just tap me the moment you want me to stop.
Ma'am, you can speak.
So today we are doing a very, very important discussion, as Professor in charge has already told us that we are talking about a very sensitive topic on which the court is already adjudicating, which is marital rape. Now, rape, as we see, is frequently constructed as an act of abhorrent lust, kind of a pathological sexual desire, or a kind of a sexual deviancy. Now, the framework in which we clearly understand rape is the one in which rape is sex, and it is not political violence, in which there is a clear systematic sexual objectification of women. Now, rape is not only a crime that affects women who are raped, but we see it in the context of, how it also causes a kind of defilement of the descent group, and it's considered to be an offense of honor. It is stigmatic for women, her family, her clan, her community, her caste, even her nation, in very specific political frames of reference. Now, some forms of violence, as we see, are not so typically criminal in real terms of experience and are marginalized in terms of recognition. That is how I would put is one such crime, which is marital rape. Now, marital rape, if we look at it, it is a common internalized sexual perversion which exists as a marital norm. And, it's an unprotested fact. So sex is considered to be a woman's matrimonial duty, which aggravates even greater, to a very greater extent, as a daily sexual, abuse and abuse experience for most married women whose husbands, claim absolute right to access their bodies. Now, there are different kinds of, as a feminist, if I talk today, there are different kinds of literature which talks about marital rape. And there are two instances which I will want even students to kind of look at, which talks on the intersection between law and politics when it comes to the question of marital rape. So one of the very important legal feminists is Susan Brown Miller, who actually says that if women are considered to be equal partners, then the intercourse must be construed as an act of mutual desire, and not willfully a duty which is enforced by, say, the permissible threat to bodily harm or because of economic sanctions. Now, this kind of sexual violence that we see against women is deeply entrenched and highly politicized. So no other allegation, of crime exposes women's credibility to such hostility, and imposes penalties which, penalties of shame and stigma to more severe degree than alleging rape. In that context, today we look into the question of consent and also the impossibility of marital rape, as our Indian laws would say. So just like incest, marital rape is an invisible crime, and marriage itself, the irony is that marriage itself becomes a robust affirmative defense for marital rape. So this is the context that we see. Now, if you look into the kind of history that Sir has already told us, that where comes the judicial sanctity? From where does this judicial sanctity come? And what is this sanctity of marriage which is already there? I'm sure most of you must have read in the papers, it is being written about very, very vividly. So it's in 1736 that we actually see that Sir Matthew Hale in his treatise talks about, the impossibility of women to be raped by their husband, So clearly, marriage kind of conveys unconditional consent, whereby wives have entered into a kind of a binding understanding, which was just a legal doctrine which was there in colonial Britain, and it influenced, in fact, the US and others. So conceptually as well as legally, while sexuality and the sexual independence, was bundled, within the ambit of the property rights, which was conferred to the husband. Now, there is a kind of understanding today, if you look into the arguments which are being presented by the court, is that there is a breach of matrimonial duty to refuse intercourse. So this is kind of the common law standard which was being followed till a few decades back, and we find the same resonance whether it was in Britain or in Europe or in the US. But today we are amongst a very few countries which has not criminalized rape. Now, if you look into the kind of discourse that has, the legal discourse, the judicial discourse that has kind of emerged today in India, there are three characteristics which I want to talk about. One is that the judges, instead of talking about a creative interpretation of law, they kind of hold on to legal formalism. And in fact, it is a kind of a legal formalism which conflicts with the basic human rights and the question of sexual equality as it is in our constitution. The second, I think, very important idea of the discourse is, the shyness in the court to look into the constitutionality of marital rape exemption. There have been many, many petitions, and this one is the one which the Delhi High Court is actually looking into. And in fact, we find that it is a missed opportunity for the court to look into it, because it is a kind of a legitimacy and, kind of a verifying the notion that, the state possesses a kind of a legitimate interest in preserving the familial harmony. That's the reason why they keep on saying that the family will be in distress and the family will be broken and etc. And it almost trumps the question of, women's privacy and autonomy interests. And the third important, I think, very important issue which emerges from the kind of judicial discourse that we are having today is about the high price of sex. So it is the high price of sex that we have today is marital, harmony. In the name of marital harmony, it is bought or purchased at the wife's expense. So these are the kind of features that definitely comes into our, a kind of subjectivity that it creates about women. So the rationale that we see today behind, these kind of exemptions, and I'm going to refute each one of them, is grounded in, say, the rationale of marital privacy. So it is said that the right to privacy is in one's marriage is so fundamental that if the court enters the bedroom, it's going to be a bull in a china shop. It's that kind of an analogy which we find. And it needs to be clearly understood that it has to be consensual. It has to be a consensual act, and it cannot definitely be a violent sexual assault. That is one important aspect of marital privacy that needs to be kind of integrated. The second important issue which has emerged in our court is about marital reconciliation. This is the most important one, where marital rape exemptions are a kind of extension of, say, the closed curtain justification, where it is opposed to the one which allows everybody to have same access to the criminal justice system for every type of marital dispute. So there very little there can be no space for reconciliation, in a relationship which is disrupted by rape itself and not just rape charge. So that's the second kind of an argument which I will present. And the third, of course, is about the evidentiary concerns. So there have been many, many questions about evidence, which I will talk in the later part of the talk. But there is also GUARD, and there are men's activists today who are actually saying that there can be false accusations made by deceitful and vindictive wives. And it is much to my surprise, for a woman to get in from a house to go to do a FIR in the police station is a very difficult act. As a married woman myself, I would say that. And, to make such complaints and that to false allegations is another extremely disillusionary argument. And I will tell you why. These are all prejudicial notions. So, if other crimes exist that are equally difficult to prove, they are yet not decriminalized, and there is no other crime in which all victims are denied protection simply because someone might fabricate a charge, and there is no evidence that wives have flooded the courts and the police stations with revenge filled Trump up charges. So if the fear of fabrication is determines actually whether a certain behavior, is a crime or not, then homicide would actually go unpunished in most circumstances. That's the first kind of argument which I will present. The second kind of argument is also that convictions are not the sole reason for enacting laws. The sole reason is also, there can be various other reasons also. For example, deterrence would be one, educational tool would be another. So it is also essential for the courts to kind of put in a message that what is morally right and what is morally wrong, what is socially acceptable and what is not. The third important thing is also that we have to contextualize in the understanding that rape itself is an extremely underreported crime. So it has social stigma, there is fear of retaliation, there is reluctance to, and moreover, to endure double victimization of the judicial system. That is an important aspect that we need to know. There is a kind of argument which also is emerging in the court. If you read the judgments and the kind of argument is that marital rape is less harmful than non-marital rape. So the perception here is that, an individual with whom the victim has had a past sexual intercourse is less severe than, say, a rape by an unknown individual. Okay, if you see the NCRB, records, you will actually know that most of the time rapes are by people who you know. And I don't see, there cannot be an argument that there is greater harm, say in a stranger rape, and there is no harm in your husband raping you. So it's an emotionally a traumatic experience, which will have a physical, which will have the marks of physical harm on you, no matter who does it to you. In fact, we say that rape is traumatic, not because it is with someone you don't know. Rape is traumatic precisely because it is with someone you don't want to have. I think that's a very important point which needs to be actually registered. But what we need to contextualize today is also to understand the kind of continuum that we see in the understanding, the colonial continuum that we see in the understanding of adjudication of rape cases. So when it comes to marital rape, there are some very broad characteristics also in the general construction of the issue. Special status that a husband and a wife has as one, which I'm sure that's the legal doctrine of united personhood, where a woman is incorporated into the personality of the husband. That's one important issue. The central important feature of the institution of marriage, as we actually see, is that the institution of marriage is considered to be permanent and irrevocable in most of the times, where the idea is reinforced again and again that women consensually enter into a sexual relationship with their husbands. Now, also upon marriage, women willingly give up their entitlement to resist any form of sexual relationship with their husbands. And the third important thing, which I think is a very important issue, is the veracity of testimony, which the lawyers have been actually fighting over. That how do you deproblematize the idea of veracity of testimony? So this brings us to a very kind of an inverted kind of a moral dilemma about the relationship that is there between individual autonomy and consent in intimate marriage situations. So what is it that will actually constitute, say, rape, that is rape, consent, marriage? So there's a construct that we see today of a hierarchy that being raped, as I told you already, by an outsider is more crime than one's own husband. That's a moral dilemma, which I say is very important for us to see. So justice in the family and justice in the democratic citizenship that we have are actually juxtaposed in such a way that they actually emerge as discontinuities, in the way in which our Indian constitutional state has emerged. Professor in charge has already told us about the history of marital rape and how there's a politics behind it. And I'll tell you how the intersection happens between politics and law here. We have the UN Committee on the Elimination of Discrimination Against Women, which was in February 2007. It recommended that India should widen the definition of rape in IPC to reflect the realities of sexual abuse experienced by women, not only inside marriage, but also outside it. Interesting is also the debate which emerged yesterday or day before yesterday in the newspapers, you would have seen, where we have our own parliament debating it. And it goes back to 2016, where we see Maneka Gandhi and others who, in a reply to a question in the parliament, emphasized that the concept of marital rape in India cannot be suitably applied because it's a West in the Indian context, because it is something that we have borrowed from the West. So it's a complicated issue. But the referred analogy was that the bedroom is a firm private space with non-porous boundaries. That's something that we must understand, that it is a space with non-porous boundaries. So whatever happens within the four walls of the bedroom should not go outside the room. I think that is something which is very, very problematic. The 172nd report on the review of rape, which was in the post-Nirbhaya context, Justice Verma committee actually recommended marital rape exemptions to be repealed through amendment. The statistics that we find today from the NFHS, the National Family and Health Survey, which is 2005-2006, has found that in India, 35% of women aged between 15 and 49% have experienced physical or sexual violence. And how many of us have reported it? That is the conjunction, that is where we need to see that if there was so much of sexual violence, there was already a domestic violence act. Okay. And there is 87.5% of ever married women who have experienced violence since the age of 15, and they have experienced it from their current husband. I think that's a lot of data for us to ponder on. And this, of course, is it's a modest estimate, because many women don't want to talk about it, just like we keep our mouth shut within the bedroom walls. So feminists have actually debated the extent to which marital rape and battering, are distinct phenomena. The central point of disagreement is whether marital rape can be segregated from other brutal forms of physical violence. I think that's a very important thing that we need to understand. One important aspect of this entire marital rape, we also need to understand that there is a brimming tension that we see between, say, individualism and family relationship. That is one important thing. And in fact, there are contesting positions in it. One is about, how can the state intervene? And the second is that the rights of the individuals should be protected from state interference in intimate choices and behavior. So these are the kind of debates which will eventually emerge, I'm sure, when the parliament will actually take it up. For example, if you guys must have done family law, you must have seen that there is a centrality in the Hindu Marriage Act. We have a central provision which is about restitution of conjugal rights. So if we actually juxtapose both of them, it actually talks about the unrapeability of wife. The only exception of a nuanced stance of advocating, say, personal autonomy in choice, it was in the court. In one of the cases which I often quote while teaching is the Sarita versus Venkata Subbiah case, where the court actually confirms that there can be a possibility of, concurring danger of judicial complicity, in marital rape, while coercing the unwilling party through the judicial process to have sex against the person's consent. I think that is one of the most modest confessions by the judge in the court. We also have various other kinds of judgments. For example, there is State versus Vikas, which actually has this is one of the judgments where they actually say the legalities of sexual intercourse after the solemnization of marriage, and it is one of the courses, one of the important judgments which has actually said that there can be no possible intercourse against the will of the prosecutrix in case it is in the in a marriage setup. So that's one kind of an argument which is there in the court. But there is also another kind of an argument which actually provides the space for any creative interpretation of law. Now we have this entire concept of compromise. If you see in the rape cases, we find that many times there is out of court settlement and there is the issue of compromise, which we often talk about. And therefore comes the question of falsity of, charges. But while there is no judicial mistrust in the settlement principle in marital rape situation, the court has actually very differentially adjudicated in rapes outside marriage. Now, let me bring that argument here for you to understand. So while dealing with the imposition of sentence, for rape, in one of very important cases which feminists read is the state of MP versus Motherlal, where the court invalidated any conception of compromise, and it says, I'll just read that out so that you will also get a feeling of it. The analogy of the body of a woman with a temple, was the context of the honor narrative. So the court says exactly in this words, in quotes, there cannot be a compromise or settlement as it would be against her honor, which matters the most. It is sacrosanct. Sometimes solace is given that perpetrator of the crime has acceded to enter into wedding with her, which is nothing but putting pressure on her. The determination to stay away from this kind of behavior is an approach of mediation which should be thoroughly and completely a legal permissibility. So clearly over here we find that the court actually talks about, that there is no scope of any compromise or settlement with the person who has raped the prosecutrix. So, because the court clearly says that here in such circumstances, the consent can be constructed, can be manipulated, can be concocted under compelling circumstances, or maybe even life experiences which can actually, subvert the matrix of justice. So it becomes a very important way for us to understand the way the court can actually use interpretation as a way to radically redefine sex and its context. A radical constitutional interpretative tradition, along with intersectional jurisprudence, which we talk about today, can actually signal gender equality in such discourses on discrimination. So any critical engagement that we see with law is more than just symbolism. This is something that all of us, whoever does research, needs to understand. Sometimes law may not be a useful tool for achieving significant social reform on behalf of the disadvantaged, say, groups, owing to the limited enforcement powers of the courts and the limited resource capacities of the disadvantaged groups. Yet, the power of law operates in multifarious ways at multiple levels at the micro level of communities. So also, its operation is not only restricted only to the juridical regime. So in an era that we live in, where we have, expanding rights consciousness, the courtroom is as much, this is something that I keep on quoting everywhere that I go, that in this kind of a context where today we are living, the courtroom is as much the center of citizen attention, as the voting booth. We must understand that. And the justice system itself gives meaning to the categories of gender. That is the fortification that we have, of rule of law in the process of, this kind of constitutional interpretation. It is necessary to move more towards the democratization of law. I think that is a very important thing that all of us must understand. And a very strategic judicial, decision-making model, which even Professor Bakshi keeps on talking about, has to be rooted in rationality that allows the court to give a statute an expansive meaning, okay, which is more inclusive, which is more equal. I think that is something that needs to be kind of talked about all the time. And when the last point which I will try to make is talking about when we talk about the question of the veracity of the evidence collection, or how do we the testimony, how do we do it? It actually brings to the forefront a very important question, that are women liars? And the court gives, actually if you look into the court judgments, they themselves give you the answer. In fact, one of the important cases of 2019, which is Sheikh Zakir versus State of Bihar, the court actually says that in the absence of medical record, where it may not be of much consequence, if there are other evidence on record which is believable. And I'm sure, if most of us who argue for marital rape to be criminalized, we say that, maybe it is not plausible to get medical record in case a woman is in habitual practice of sexual intercourse. But what about the history of physical violence? I mean, can that be refuted? What about, say, electronic communication, that is between the husband and the wife? Or say, what is, if there is a medical examination of, very critical, damage because of forceful intercourse. And also, we need to understand that there cannot be any binaries between good rape and bad rape. Rape is rape. There cannot be any existence of this kind of a rape is permissible and therefore this is good rape, and this kind of a rape is not permissible and therefore it is bad rape. So I think that if we actually think about how testimonies can be recorded and how evidence can be collected, then I'm sure, it is possible. And in fact, all over the world today, where there are criminal laws which have done away with marital rape exemption, the principle which has been used in different states of America is that the history of physical violence has been an extremely important element in looking at marital rape. I think that is something that even India can move forward to. It may not be a very easy thing to do, but it is something that all of us need to actually think and rethink in the way some colonial rule needs to be reframed, and at least for the sake of women who are in massive abusive relationships, intimate relationships with their husband. I think that's all that I would say. And the last remark that I want to make is, like I said, that rape is not traumatic, not because, it is with someone you don't know. Rape is more traumatic because it is with someone you don't want. I think that is something that I will leave you with to think about. Thank you.
Thank you so much, ma'am, for that.
It's 20 minutes, I believe.
Ma'am, we have a time. We had a blast hearing you, ma'am. So we couldn't keep a track of time, but it was wonderful hearing you. Thank you so much, ma'am. Now I would like to request Shonee Kapoor sir to step up and address all of us.
Anita Tagore ji, thank you.
Thank you, sir.
Am I audible?
Yes, sir, you're audible.
Okay. So I'll start with thanking Law Center 2 for having me here on this topic of marital rape. Before I start, I'd like to pay my respects to Dr. Vageshwari, who taught me criminal law. I'll also like to pay my respects to Dr. Mahavir, who is professor in charge there. I was listening to Dr. Anita, and it reminded me of a self-proclaimed feminist who once made a statement, and she said that anyone who does not agree with us is rooted in patriarchy and is a misogynist. Vaginal form of violation is the gravest form of violation. I think society and courts, they largely agree with her. It is so grave that last year, out of 62 people who were sentenced to death, 44 have been guilty of vaginal violation. It is so grave that terrorists and gangsters who kill many other human beings are not tried and sentenced for years altogether. But for this violation, we have fast-track courts. And in very few reported and celebrated cases, in less than a month, accused has been sentenced to death. Police killed 4 accused in Hyderabad rape case, Hyderabad Nirbhaya case as it was called. The whole nation celebrated in ecstasy, euphoria. Whereas the terrorist who killed 257 people in Mumbai blasts, or who was involved in parliament attack, or who was instrumental in killing 175 people in Mumbai attacks, they went through a long cases and they were proven guilty. Still, it took government years to hang them. And eventually when they did, they were hanged because of political considerations. In 21st century, where we are, out of 8 people who have been hanged in India in this century, 5 was for this violation, vaginal violation. 3 others were terrorists, I mentioned. Now, essentially, what we are saying is that woman who has been so violated suffers more mental, physical, emotional, and financial pain than all people who are dependent on multiple people, which include men, women, wives, children, parents, who are killed by terrorists or who are routinely killed by gangsters, and not to say that the person who has lost his life himself. Heterosexual males in our legal systems are perceived to be the only active aggressive party. Let me repeat. Heterosexual males in our legal systems are perceived to be only active aggressive party. All other are passive victimized parties. That is the truth about our legal system today. So much so So much so, when the courts, when we approach courts and when people have approached courts, they, whenever they want to create, amend, delete any sections of IPC or create a new law, when it relates to females, transgenders, homosexuals, they are ready to amend it. But when it comes to, when people go asking for any amendment, addition, or tackling misuse of criminal delivery mechanism affecting males, they wash their hands, saying that it is the domain of legislature. Give me a minute to explain further on what would happen if this exception 2 goes away. Because when Dr. Anita was talking, and when most feminists talk about marital law, they often use to define rape as violent sexual assault. But what they ask is merely deletion of exception 2 in section 375 of IPC. So these are two totally different things. Let me read, give me half a minute to read what is consent under 375, section 375 consent. It is defined as clear, voluntary communication that the woman gives, either verbally or by signals, for a sexual act. Marital rape is an exception to this consent. Section 375 further says, provided that a woman who does not physically resist to the act of penetration shall not, by the reason only of that fact, be regarded as consenting to that sexual activity. Now, let us juxtapose it with section 114 of Indian Evidence Act. So 114 of Indian Evidence Act, 114A of Indian Evidence Act. It says that presumption as to absence of consent in certain prosecution of rape cases. So in the prosecution for rape under clause A, B, C, D, E, F, G, H, I, J, K, L, M, N, or subsection 2 of section 376 of Indian Penal Code, where sexual intercourse by the accused is proved, and the question is whether it was without the consent of the woman alleged to have been raped, and such woman states in her evidence before the court that she did not consent, the court shall presume that she did not consent. And in section 376(2), husband would invariably fall in following 4 categories as per definition. He is a relative. It says being a relative, guardian, or a teacher, or a person in position of trust or authority towards a woman. He commits rape of such woman. So husband is a relative. He is also considered to be guardian and a person in position of trust and authority towards a woman. H says commits rape on a woman knowing her to be pregnant. So that means any sexual intercourse during pregnancy. K says being in position of control or dominance over a woman. So it is considered that it is accepted that husband has control and dominance over a woman, over his wife. And says commits rape repeatedly on the same woman. So a husband and a wife would normally indulge in sexual intercourse at various times. It says shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and shall also be liable to fine. Now we are saying that merely when a woman goes to police or court and says that I was raped, a wife goes and says I was raped, the court should not look at any other thing because exception 2 has been taken away. There is nothing which says about any kind of violence which happened. Merely on the statement of a woman, the person, the man, should be punished for not less than 10 years. For not less than 10 years. And there is no violence involved. Please understand this. Merely taking down exception 2 would mean this. Dr. Anita also spoke about National Family Health Survey of 2005 and 6. I had also noted it down. And there were 80,000 women who were interviewed in that particular survey. And there came an exceptional piece of, statistics to my mind, to the light, and I noted it. And it says that 93% of such women, 93% of such women had been sexually abused by their current or former husbands. Recently, we MRAs were tweeting on hashtag marriage strike. I think feminists should have been running that hashtag because if that is the case, we should ban marriage itself. We should not criminalize if 93% of women, as per that particular survey, are abused sexually in their marital life. We should ban marriage itself. There would be no better reason to ban marriage in this country. Merely 7% of people or males ask or seek any consent. If we talk about that sexual intercourse, we are talking about marital rape in which sexual intercourse is coupled with violence or any other cruelty, then let me assure you, there exist certain provisions even today in our laws. Section 498A of IPC talks about two kind of offenses, in which one particular offense is cruelty under this section. For the purpose of this section, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of that particular woman. Now, if we take this definition and if there is cruelty attached to the sexual conduct of the husband towards his wife, it is a punishable offense even today. There can be tinkering about the quantum of sentence here rather than merely taking down exception 2 of section 375. Now, let me talk about certain statistics because there is a lot of discussion about that how most women does not come to courts and does not report the crime, and also that no woman will report a crime of such nature because there is a lot of other things involved and her own honor is at stake. DCW works for women, Delhi Commission of Women. In its survey, in its report in 2014, and no, I'm not talking about today. In its report in 2014, it said that 53% of rape cases are false in this country, in this state. This is not my data. This is not National Crime Record Bureau data. This is data by Delhi Commission of Women. Delhi Commission of Women stopped publishing any further data after that about how many rape cases they found to be true or they found to be false prima facie. The Hindu did a great survey about over 600 cases in Delhi courts and found that 87% of these cases either involved elopement of young people in which statutory rape was there because the age of the girl was less than the consenting age, or they were on false promise of marriage. That means that a man promised that he'll marry the woman and thus had consensual sexual intercourse with the woman, and then he did not carry on with his promise and he did not marry this woman. This said, currently there is a vogue of extortion under the gab of rape cases. In fact, I just wanted to tell you something which I forgot. And I am the producer of a movie called India Sons, which is a tale of few false rape survivors. We have currently, along with Deepika, who is the director of that particular movie, we have found a case in Gurgaon. There is a female by the name, of course, we should not name the prosecutrix. So there is a female who has lodged 8 rape cases in 8 different police stations within a span of 1 year. And all cases are rape on the pretext of marriage. And this is when this particular woman is married, already married, and she is fighting a case against her current husband. I have also been instrumental in, bringing to light to more sextortion. I would say sextortion because there the cases of rape were filed to extort money. Sextortion rackets beyond besides these. So at least I won't take this statement that woman's statement, a female statement in sexual offense cases is to be treated as gospel's truth. No, it is not the case. It is very far off from the truth. A woman and a man, they can go to any length when they want to wreak havoc on other parties' life, be it in marriage, be it otherwise. So whenever we are asking for creation of a new law or taking down exception from any particular law, we should look at the societal impact of those particular things which are asked to be done. I, for one, despite being from men's right or fighting for men's right, do not say that marital rape should not be a crime. Let me reiterate. My take is solely that by knee-jerk reactions, the way we created after Nirbhaya, amended the laws after Nirbhaya, and after Unnav and Kathua rape cases, this is not the way to make or amend laws. A lot of research needs to go before making a law. And also some insights, some surveys, some effort should be made to find out what will be the impact of such laws. There is a very genuine need currently of 2 things. First, sexual laws in this country should be made gender neutral. Secondly, because we are making benevolent provisions of law in which registering a case is very easy, there should be a strong punishment for misuse of these particular laws. You would be surprised that despite the statistics of 53% or 87% of false rape cases, or conviction rate as low as 19 or 20%. Not even a single woman has ever been convicted for filing false rape cases. Maximum they are fined for 10,000 rupees or 50,000 rupees. And in cases, men have spent years and years in jail. Another thing which I would like to say, that the name of the prosecutrix is not revealed in public. So similarly, the name of the accused shall also not be revealed in public, because there is more than fair chance he would be acquitted, but his name would be there as a rapist in Google search, in all searches, in newspapers. We covered a story of gang rape, false gang rape, in which the people were acquitted twice of gang rape of the same woman. But even today, when we go on YouTube, their name, whenever they search their name, news reports come about they being alleged rapists. So as much as we want to work towards safety, security of women, I think the respect and dignity of men is also equally important. Else it may happen tomorrow we may not need males at all. Even today, chicken industry does not need males. A male chick is killed right when it is born. In bovine industry, a male is sent to slaughterhouse at the age of 2 or 3. Males would be expendable commodity in human race also if such laws are made and not enough safeguards are not kept. Thank you very much.
Thank you so much, sir, for sharing the whole incident with us. We thank our speakers for providing such insights on the topic. I'm pretty sure everyone, including us, learned a lot from both the speakers.
Thank you, Kanak. Before we move on to the question answer round, I would kindly request Vageshwari ma'am to say the concluding remarks.